Hello everyone, I am Vivek Gopalpuria, Director of Product Marketing at Replicon. I welcome you all to this session that deals with one of the hot button topics we have for businesses today, overtime regulations. Here we try to trace back the changes that have been proposed in the last 1 year. To help us with this, we have Brian Dixon from Littler. He's an expert at wage and hour compliance. Over to you, Brian, for a quick introduction.
And I have had the opportunity to write a few books on the subject, one for SHRM, which turned out to be a little bit of a bestseller. And I've also had the pleasure of being on a wage board of California's Industrial Welfare Commission. And I co-chair the firm's practice group of about 350 wage and hour lawyers. I'm very pleased to be with you this morning.
We are excited to have you too, Brian. So the agenda for today, we will quickly introduce overtime. We will introduce some statistics around overtime litigations. Then we'll dive straight into the changes that were proposed last year, the revised changes this year and their impact on businesses. We will follow that up with a Q&A session. Before we start, a couple of housekeeping items. All of you will be on mute during the session. The question and answer session will be at the end of the webinar, but you can ask your questions at any time using the questions box. Also, we have a poll during the presentation and we highly appreciate your response. All right, then let's dive right in. What is overtime? As most of you would know, overtime is additional compensation paid out to employees for any hours worked over the regular work week, and this could vary depending on where you're at. It could be 40 hours over the week or sometimes even 8 hours in a day. Overtime is usually paid out at 1.5 times the regular pay rate. Employees who are eligible for overtime are called non-exempt employees, and those who are not eligible for overtime are called exempt employees, exempt from overtime. The Department of Labor has defined 3 tests to determine exempt versus non-exempt employees. The salary level test talks about the threshold that needs to be paid to the employees, and this is set by the Department of Labor. The salary basis test actually looks at if the employees are being paid a guaranteed minimum regularly as salary, irrespective of hours worked. And then we have the duties test to check if the employee actually supervises, is part of management, does professional or administrative duty, or is actually non-exempt. Moving on, businesses generally find overtime very difficult to comply with, and here are some of the reasons why. First of all, overtime rules are, as you all know, complex and subjective, so consistent application of these is difficult. There is a lot of variation by location. There are federal rules, there are state laws, there are city versions, there are collective bargaining agreements, and then there are internal business policies around wage and hour. All these stack up and make it difficult for organizations to comply with. And then you have the changing dynamics of the workforce. You have the rise of the mobile and on-demand workforce and disruptive technologies that are enabling these employees to work from anywhere, anytime. And all these have made compliance and especially management of overtime very difficult. Let's look at a quick stats to prove this out. So wage and hour cases are the most active types of litigation in employment law. We have had about 9,000 filings in the year 2015. This was up from about 8,000 the previous year. Since 2000, there has been a 450% increase in the number of FLSA litigations. And most of these are actually around overtime. So overtime is the most common type of allegation in litigation settled, comprising of 42% of cases. And whenever there is a back wage involved in an FLSA violation, there is usually an overtime associated with it. This just goes to show how businesses are struggling to keep up with FLSA and overtime in particular. Having set the stage, I would like to hand it over to Brian to talk about the proposed overtime changes in detail.
Great. Thanks, Vivek. And I'd like to thank Replicon for inviting me to speak today. I've always enjoyed working with everyone at Replicon through our seminars, and happy to speak with you all today. We had major changes, which most of you are very aware of, but I think it's worth recapping them briefly and getting a little perspective on the subject. Overtime has been required under federal law since 1938, the worst year of the Great U.S. Depression. The overtime exemptions came into play immediately after the law was passed. It was 2 years before there was the first salary test, interestingly enough, for exempt status. But the salary pay test has largely languished between 1958 and 1975. It was only increased 4 times in that period of time, and then it sat without any change from 1975 to 2004, a period of 29 years. And after the changes in 2004, it languished for another 12 years. And the Obama administration, President Obama gave a direction to the Department of Labor to address the salary pay test with a great deal of emphasis, and also not only to address it once, but to make sure that it continued to increase in the future. So what we had proposed to take effect last December 1st was an increase in the salary from $23,660 a year, that's $455 a week, and it is important to remember that the salary pay requirement operates week by week, to double to $47,476 a year, which would take it up to $913 a week. Not only would the salary increase, but it was indexed to rise every 3 years thereafter. And the benchmark was the 40th percentile of full-time weekly earnings in the southern census district. So there was certainly an expectation that the salary would increase with regularity, although it was tied to a somewhat more modest market test of what it should be. The most novel aspect of the new test was that non-discretionary bonuses and incentives could be counted towards making up the $913 a week salary, or up to 10% of it. Surprisingly, what could be counted there was defined rather broadly. Any bonus or commission or other incentive that would go into the regular rate of pay could be considered to be non-discretionary, even if the employer retained pretty substantial control over it. There were, however, very tight timelines to make sure an employee was in fact paid the additional 10%. You only had one pay period after the end of each quarter in which to true up or make up the deficit between any non-discretionary incentives that were earned and the minimum amount needed for that quarter. We also saw a sharp rise in the amount that had to be paid for highly compensated employees, the HCE employees. You still had to pay the base salary of $913 a week without really any credit for non-discretionary bonuses and other incentives. However, once you got over the $913 per week, you had the ability to use non-discretionary bonuses and incentives to make up the balance. So we had some very, very substantial changes there. Let's move forward and look at the timeline of how those changes came to grief. In September 2016, 2 major legal attacks were filed against the new rule. One attack was mounted by 16 states. The other was mounted by a wide variety of business organizations, primarily chambers of commerce. The suits were filed in Texas and were consolidated by the courts. Both lawsuits essentially contended the same thing, that the salary was just too high and that it, in a sense, superseded the duties test. The statute actually says that the exemption is to be measured by duties and delegates authority to the Department of Labor to define what those duties would be. Second major contention was that indexing future increases was invalid. It never occurred before, and actually the history of long intervals suggested that Congress was more interested in leisurely regulation of the salary pay rather than active regulation of the salary pay requirement. And the states argued that the mandate for a very high salary, which would affect all of the state employees, impermissibly invaded the separation of federal and state powers that was intended by the Constitution. Again, the business tax was the same. The rule was to take effect on December 1st, but on November 22nd, the district court in Texas issued a nationwide injunction against implementation of the rule. I always find that it's interesting that the states should complain that the federal government is not respectful of the separation between federal and state governments. After all, the federal government is made up of state representatives, but there must just be something different in the air in Washington, D.C. But the air in Texas is certainly different. The district court judge stepped up and issued the injunction. The rule was to go in effect on December 1st, but instead the Department of Labor found itself appealing the court's decision to the Fifth Circuit Court of Appeals. The Obama administration, Department of Labor, still in office at that point in time, but knowing their era would come to a close, asked for expedited briefing of the subject, hoping, I think, to get to the end before the Trump administration arrived. And the Fifth Circuit initially granted that expedited briefing. However, on January 20th, the Trump administration took office, and the Trump administration immediately requested a great deal of time, several extensions of time, to file its reply brief. And we'll talk about that reply brief because it's very important to us in a few minutes. At the same time, the Department of Labor filed a new request for information, which is a precursor to what we call an NPRM, a Notice of Proposed Rulemaking, as the Trump administration is relooking at the salary pay level. So let's go forward again, and let's look at some of the choices that the administration has and Congress has and the Department of Labor's rulemaking choices. The litigation choices for the Department of Labor were sort of interesting. The problem that actually exists in the litigation, both for the Department of Labor and for the employers, is what was it exactly that the court held? This district court in Texas concluded that the significant increase to the salary level creates essentially a de facto salary-only test instead of a duty test. For instance, the Department of Labor itself estimated that 4.2 million workers currently ineligible for overtime would fall below the minimum salary level and be eligible for overtime. The court went on to restate its thoughts in a fashion that was not always entirely consistent. The court went on to say the plaintiffs established a prima facie case at the department's salary level under the final rule and the automatic updating mechanism are without statutory authority. And notice the emphasis on the salary level and not the salary itself. But then in its ultimate conclusion, the court said, the statute really doesn't grant authority to the Department of Labor to use any salary level. Now, that really raised everybody's eyebrows because the Fifth Circuit Court of Appeals, which will hear this appeal, had ruled long ago in the 1960s that, in fact, there could be a salary pay requirement. So what are the choices for the Department of Labor on the appeal? They could defend the entire rule. They could defend the salary increase, but just abandon the indexing, which irritated a lot of the indexing, irritated many people. They could defend the application to the states or just let the states go, so to speak. They could concede the entire rule was invalid. Well, what they did in their brief that was filed on June 30th was say this. The department has decided not to advocate for the specific salary level, the $913 per week or $47,000 per year, set in the final rule at this time, and intends to undertake further rulemaking to determine what the salary level should be. Accordingly, the department requests that this court address only the threshold legal question of the department's statutory authority to set any salary level, but without addressing the specific salary level. Well, that puts us in a very, very interesting space, because the Department of Labor certainly doesn't control what the court may do. It's nice when the defendant concedes a major point, but again, it's the court that controls the disposition of the injunction. The court may say, the only thing that the Court of Appeals may say, the only thing the district court really decided was that you could not have any salary test and may well reverse. And if it does reverse, what happens? And there's an analog to that, and the fear is that the rule will take effect. And not only will it take effect, but when will it take effect? Will it take effect when the Court of Appeals rules, or will it take effect? Will the court say, the original rule was valid, and we don't have any basis to enjoin it? There's been similar litigation in the home care industry, and in the home care industry, the industry challenged some Department of Labor rules that spread overtime to many home care workers. The home care industry was initially successful in the district court. The Department of Labor appealed, and they won in the circuit court. And the circuit court, and after that, there have been many lawsuits around the country where home care workers have sought overtime. And the industry, of course, has argued, well, the obligation to pay overtime only extends from when the circuit court said that the district court should have never issued that injunction. But the courts are pretty much split. Some courts have said, if the injunction was inappropriate in the first place, then the rule was valid, and the rule was valid when it was issued, not when the Court of Appeals finally got around to it. Employers, of course, argue that if the rule is enjoined and could be retroactively applied after the court's decision, then they have to comply with what may be an invalid rule until the very end of the litigation, which would perpetuate obligation they should never have. So this is a very sensitive subject. It's not really clear which way the Court of Appeals will rule on the subject. We have to probably take some guarded approaches, some what-if approaches, at least on a guarded basis, to figure out what would we do if the Court of Appeals declares the salary pay rule to be valid, and when would it be valid? One thing we want to bear in mind is, Congress still sits there. There was a decision regarding what was compensable hours of work way back in 1947 called Anderson versus Mount Clemens Pottery Company. And in the Mount Clemens Pottery Company case, Congress defined work time in a very expansive manner, which was much greater than what most employers considered work time to be. It included walking time once you got on the employer's premises, for example. And what happened was that Congress passed what's called the Portal-to-Portal Pay Act. And the Pay Act relieved employers of liability for a period of time if they met certain requirements. It also reversed and narrowed the definition of hours of work to be much narrower than what the Supreme Court had ruled. So we do need to be sensitive to the fact that, if we do have an adverse outcome or surprise from the Court of Appeals, the answer may be to energize your local industry association and contact your local congressmen and women and see if you can get some initiative started towards a congressional remedy for the subject matter. One of the other things that we do want to be sensitive to, and as I pointed out at the end of the last slide, is that the Department of Labor has submitted a new request for information that's a precursor to writing a new regulation. And the Department of Labor's request was submitted on July, or the RFI is now, was submitted in June, I believe, and is now publicly available with a July date. And what's really amazing about the RFI, request for information, is its breadth. And the request for information, it will ultimately be open to public comment. And again, I think it's very important for you on the program, participating in the program, that if you're concerned about the salary pay level, again, I think your best option is to contact your industry association and help them formulate a response to the many questions, 11 to be exact, that the Department of Labor has put forward. Then one of the questions is, should they follow the standard that was used when the current 455 per week salary was set, which was looking at a 20th percentile test of employees in the South rather than the 40%, the doubling that the Department of Labor would use. Another is the very challenging question of, should there be a single salary pay test across the United States, or should there be multiple standard salary levels depending upon the size of the employer, the census region, the state, the metropolitan statistical area, or some other method of differentiation? And should there be different salary levels for executive and administrative employees as opposed to professional employees? Because thinking back prior to 2004, going all the way back to 1963, there was a lower salary level for executive and administrative employees than there was for professional employees. Prior to 2004, there were also long and short tests that were much more comprehensive than what we have today. Today we have a very high salary test and then a basic test. In the past, there were long and short tests which were much more closely related to each other in terms of the difference between the salary. And the interesting question of whether the salary was set so high in 2016 that it eclipsed the duties test is one of the very important questions that the Department of Labor is asking. They also ask if duties only without a salary would be appropriate, and the several other related questions. They ask also about whether including non-discretionary bonuses and incentive compensation is appropriate, and how many different levels should there be. And the last question, of course, which is the one which garnered so much attention in the litigation, and that is, should there be an automatic increase aspect to the salary pay basis? And those are important questions because, I think I think we would all agree that predictability is a very important part of our compensation planning and our budgeting. And rather than have increases at irregular intervals, having, reasonable, modest increases at predictable intervals might be a better answer. We do have to appreciate that as administrations change, the perspective on what is appropriate may change, but we definitely need to keep that in mind. The other thing pointed out in the previous slide is that there was a lawsuit filed against the Chipotle restaurant chain. And it's a very interesting lawsuit because it attempted to build on, again, the district court's conclusion, which enjoined the department's final rule, and then goes on to say specifically defendants are enjoined from implementing and enforcing the rule. So the Chipotle lawsuit says, hi, I'm a private plaintiff, and I am not the Department of Labor, and therefore I am not enjoined. And the only thing that the district court, the argument is that the only thing the district court ruled on was whether the Department of Labor could enforce the rule. It's a little bit of a play on words. I think the argument of the plaintiffs needs perhaps a little more hot sauce, to use perhaps a relevant metaphor there, because the preceding sentence in the court's order is that the department's final rule is hereby enjoined. And that doesn't leave any latitude for private enforcement any more than it does for public enforcement. But I think the thing to bear in mind about the Chipotle lawsuit is if, and this, I don't have to say that, we don't want to indulge in negative speculation, but one can easily extrapolate the effects of what if the Fifth Circuit were to simply say, well, the Department of Labor can have its salary test, but we otherwise don't agree with the district court, and the salary pay rule can go into effect until and unless the Department of Labor amends it, there could be a period of a very substantial upset in that intervening period of time. And again, I'm not predicting that would happen, but I do think that it's probably prudent to have a little bit of what if planning around what if the rule should go into effect. So let's roll forward and take a look at, in the meantime, back on the ranch, so to speak, what are the states doing? And the answer is quite a bit. There are several different approaches on the state level, because the states are free to regulate whether they have overtime or not. The states are free to regulate whether we're going to have exemptions from overtime or not, how broad those exemptions should be. They don't have to look like the federal exemptions. Many states, they do not look like the federal exemptions. And they can regulate, if they want, what's the minimum compensation requirement to be exempt. One really vivid example of how state regulation can vary from one location to another is if you look at the outside sales exemption. The exemptions vary tremendously. Some states set a very, the federal rule is you have to spend more than, you have to customarily and regularly be engaged in outside sales, which customarily and regularly could be a very small percentage of your time. California, you have to spend more than 50% of your time away from the premises making sales. I believe Pennsylvania is 80%. Oregon's combination exemption, 70% of the time away from the premises making sales. Similar variations for computer professionals. There's a federal exemption for computer professionals. Many of the states that require overtime have a similar exemption, sometimes similar, sometimes different. Some of the states that require overtime have no exemption specifically for computer professionals, which makes it quite a challenge to classify people. You're very heavily relied upon systems analysts and developers and software engineers as exempt. One example would be Pennsylvania, which has no specific exemption for computer professional employees. That being said, let's talk about what is the minimum salary level when we do have an exemption for white-collar employees. And the models that the states use vary a good bit from one jurisdiction to the next. In California, the minimum amount necessary to be overtime exempt is set at 2 times the minimum wage for a 40-hour work week. So it's 2 times 40 times whatever the minimum wage is. And that may not sound too overwhelming, but we need to realize that California has just passed a short time ago a bill that will increase the minimum wage steadily year by year until the year 2023. And so right now in California, the minimum amount to be overtime exempt for an employer of more than 26 or more employees is $43,680 per year. That will increase to, I would say, a relatively amazing $62,400 annual salary by 2023. Alaska uses the same formula, 2 times the state minimum wage for a 40-hour week, but the minimum wage is somewhat lower in Alaska. So right now, the minimum salary to be exempt in Alaska is $40,768 a year. New York has just gone through a rather tumultuous process of enacting a new minimum wage that is varies substantially as you go around the state. There is, something to be said for there's New York City and the rest of the state, and the legislature seems to agree. If you look at large employers in New York City, the minimum amount to be exempt is now $42,900 and will increase up towards $60,000 by 2019. Interestingly enough, there are some states which have just tackled the minimum salary head on, and these are pending legislative proposals. And it's not something to run out and redo our comp structure, but we do want, if we have employees, for example, in Connecticut and Rhode Island, Connecticut has proposed that the minimum salary be increased to $50,400 a year now. And Little Rhode Island would make a mighty step upwards to a minimum salary of $53,872 per year, which would well eclipse even the blocked federal proposal. Again, those are legislative and administrative proposals that which you keep an eye on if you have exempt employees in those states, and update as you must. One of the other interesting things that is a derivative of the great deal of legislation and local initiatives around the minimum wage is there are a few states where employees who are overtime exempt, such as your basic supervisor, your executive, administrative, and professional employees, are not exempt from the receipt of the minimum wage. And if you work enough hours and the minimum wage has increased enough, it could just catch up to you. For example, if you're a hardworking employee in Colorado, given Colorado's current minimum wage, if you work 60 hours a week every week, your annual salary would have to be $29,016 a year. That's at 60 hours a week. That's a very somewhat unusual circumstance, but nevertheless one we have to keep in mind. The minimum wage is coming up slowly around our ankles, I would say. Let's look at another major change that it's in the offing, but one that we should keep an eye on. That is the possibility of compensatory time off coming to apply to private employers. Right now, public employers, of course, can use compensatory time off. The Workplace Families Flexibility Act, which was introduced in Congress, passed Congress by a relatively close vote of 229 to 197 on May 2nd, and is now pending in the Senate. And it's a good introduction to a few concepts to look at this. One is it might actually get passed given the current composition of Congress, and we need to know about it. The second is we need to know about state regulation of comp time. And lastly, we need to know what are we doing about comp time today? Can we use comp time without this statute? I think we've covered all three of those subjects. The new bill requires either a collective bargaining agreement or a voluntary written agreement with an employee to use comp time. The core of this is it must be time and a half off with pay for each overtime hour worked. A little complication here is that when you give the comp time, you either have to use the regular rate of pay, that would be including things like shift differential, lead person premiums, bonuses, and commissions, when the comp time was earned or when it was paid. So we're definitely going to need a robust payroll system in order to make sure that we pay the comp time appropriately. You can only use comp time if you've worked 1,000 hours in the preceding 12 months before the agreement with the employee or the receipt of the comp time off. This avoids spiking in the sense that an employer would suddenly hire for a short period of time, large number of employees, have them work many hours, encourage them to just take comp time and thereby avoid the burden of overtime. But it certainly adds yet another layer of complexity in the payroll processing software. There are many cash-out turning points in the statute. Any unused comp time as of December 31st of the year, last day of the year, must be cashed out by January 1st of the following year. An employer can elect to cash out any comp time in excess of 80 hours on 30 days notice, allows you to take it off the book, so to speak. An employee may request a cash out on 30 days notice, which is a very interesting provision because if for whatever reason, say there was a union organizing drive and there was a lot of accrued comp time, and as part of the organizing drive, a concerted effort was made to cash out all of the comp time, we might have to draw down the line of credit in order to make sure that we could do that. And of course, employees must be cashed out on termination. During employment, an employer must permit use within a reasonable period of time after a request is received from the employee, but the request cannot unduly disrupt the operations of the employer. That's really a rub point here, I think, for a lot of comp time. In the public sector, under federal law, there has been the opportunity to use comp time for many years. A lot of the litigation surrounded how precisely, how quickly must an employer respond to a request for comp time, and can that request for comp time be targeted to a particular day or a time, or can the employer retain control over when that would be used? We have also a cap on the accrual of comp time, as we do in the public sector. In the private sector, the cap on the accrual of comp time would be 160 hours cap. After you reach the cap, any additional overtime that is worked would have to be paid out in a timely fashion. regular pay days. So let's roll forward and look at some of the responses to the new comp time bill. Supporters, of course, allow employees to decide if they want to comp time or pay overtime. That allows a lot of flexibility. Flexibility is a very high point these days. There's certainly a long history of organized labor favoring work weeks of 5 to 8 hour days a week, but modern lifestyles don't always correspond with that. There are also options for employers here, so in some regards it looks like a win-win. To the extent that employees want to utilize comp time, of course, it's voluntary. You could avoid some of the peaks and valleys in your payroll cost as you have busy seasons and less busy seasons. The opposers really are focused on, the possibility that an employer would take advantage of the situation. And parallel to that, there is a provision in the bill that an employer cannot intimidate, coerce, or retaliate against an employee for utilizing or not utilizing comp time. Opponents do point out that an employer has to approve when comp time is used, which, in some regards gives the employer a little bit of a pipe wrench on the entire comp time process. Let's roll forward one more time and look at how some of the practical things that might impact the business here. And we've talked about these to a fair degree, so I'm not going to focus upon them unduly. We do need process. We need robust timekeeping system. We need a robust payroll processing system. We need policies that will reflect the use of comp time. We need to train supervisors as to, when to approve comp time requests and when to approve time off requests. So it's a fairly robust undertaking. I know, for example, here in California, we have the opportunity to have makeup time, which is sort of comp time on a miniature scale. We have daily overtime, which is why makeup time is so important. You can work a couple extra hours one day and then take some time off without pay on a straight time ratio on another day. But many employers find the use of makeup time to be so complex, so inconsistent with their payroll processing system, requiring, you could certainly program your time clocks to accommodate makeup time, but some employers just say, it's not worth it. So ultimately, as an employer, you would have to make the decision, is it worth it for me? Let's roll forward one more time. And we've covered the new statute with pretty fair detail, so I'm just going to take a minute or two for anyone on the phone, anyone on the program feeling slightly guilty about using comp time now in the private sector. What are the rules around that? And, the basic rule is today, before we have any comp time statute, that you have to pay all wages due every pay period. You cannot defer comp time to the next pay period. What does that practically mean? That means, well, if I can only use quote unquote comp time if somebody works overtime in the first week of the pay period and takes the time off in the second week of that same pay period, then the employee is cashed out by every payday. And I'm feeling, like that's okay. But there are still some issues that we need to be mindful of. One of the funny things about comp time that over the years has always been a sticking point is, you could always just pay the overtime and say, look, you can take unpaid time off the next week, but it never really resonates with employees. They want to know that I work some extra time, but I'll be paid for these hours the next week when I'm actually not working. And that, of course, leads to, if you were to implement comp time today along the very limited lines that we can, which is taking comp time in the same pay period, you'd have to add a couple interesting columns to your timesheet. One would be time worked but not paid for. That's the overtime that I work, but I want to get paid for it next week. And of course, the Department of Labor would be very interested in that column on your timesheet. The other is time not worked but paid for, and that is next week I'm getting paid for time I took off. And your board of directors might be very interested in exactly why that column is showing up on the timesheet. So we need to be sensitive to the fact that Comp time can be a very complex issue. I think the largest issue that we have with comp time when an employer starts using comp time and they don't have the extra columns on the timesheet. People are working hours, not writing them down, and then, the supervisor is sort of keeping a little list on the back of the calendar, the desk calendar. It used to be a desk calendar. In the Outlook calendar, worked a few extra hours, take a few hours off next week, then you've really impeached your time records as an accurate record of hours worked. And then you're vulnerable to any employee saying either, I didn't get cashed out for all my comp time, or you're also vulnerable to people saying, well, I worked off the clock and now the payroll record's not reliable. We have a much larger problem. Another thing to keep an eye on is exempt employees in comp time. Very sensitive subject. If you get a little too precise in promising extra compensation even to an exempt employee, the employee can collect it. If I say for every hour over 40 you worked, I'll pay you. If you're truly exempt, we can pay additional compensation to exempt employees for extra hours worked above their regular schedule. You don't have to, so you could pay it at straight time, you could pay it at half time, you could pay it on whatever basis you want, but if you promise it and you accrue it, then you may have an obligation to pay it out. If your promise is specific, there's no law that prohibits you from promising more than what the law requires. And especially in states where, vacation compensation, if you're promising paid time off, it could well be considered to be vacation compensation and subject to all the rules of the state regarding vacation compensation. So at one point in my career, I was dead set against comp time for exempt employees, but one of the things I noticed is that there were many fewer claims that I was misclassified as exempt in organizations that had comp time. It's a very subjective impression, but my impression was that the comp time actually was a little sort of buffer of satisfaction that helped minimize certain claims. Let's go on and look at what state laws are around comp time. We always have to realize, today, compliance in the wage hour arena is federal law, state law, and local law, because we see a lot of local initiatives. Here is a list of requirements to use comp time in California. Right now, they're a moot point because, in the private sector, the federal law requires us to cash out all overtime every pay period. But if the new comp time statute came into play on the federal level, you would then have to pick up the state labor code and make sure that you looked at these, and you comply, of course, with both sets of laws. And that means while California might allow you to accrue up to 240 hours of comp time, the federal proposal in the private sector is only 160 hours. And one thing I would keep a real eye on is the second bullet up from the bottom. There's a long list of industries that are excluded from the ability to use comp time. So again, state level regulation can be extremely important. Let's go forward, and I think Vivek's going to come back and ask us a little bit of a poll question here. Vivek?
Thanks, Brian. So the audience will be able to see a poll question on their screens right now. They have about 30 seconds to respond, and your response is highly appreciated. So the question is, how will the proposed overtime changes affect your business? And your options are, it will have a major impact, you expect a minor impact on your business operations, you expect no impact, you're not sure of what the impact would be. We'll give you about 30 seconds for responding. Will the poll result be? Well, my bet is on a major impact because all these overtime issues and litigations point to the fact that businesses are struggling to manage their overtime. Let's look at the poll results now.
Well, that's certainly an interesting outcome. I think the net we may see there is that some of it is, okay, we've got all the additional rules for comp time. Is this really going to be something for us? Or since we have to pay it all eventually, is it better just to pay it, as so to speak, as we go? And that is certainly a very important consideration. Why don't we take a look at our next and my last slide, and then we'll go to questions and answers after that. And if we can go to the next slide. And let's see. There we go. So in closing, the few things I'd like to say are these. We have to be very aware of the need for accurate record keeping. It's ever more important. One thing that there are several things I would always recommend, which are the more precise your record keeping is, the better you are. If you, rather than rounding time, I think your better solution is more time clocks closer to work areas. And it's possible to do that on a cost-effective basis today. Having rounding invites disputes, especially if you use rounding to the nearest quarter hour. Little issues like having, pre-shift meetings or a strict rule against tardiness, which means everyone arrives early and starts work early, are to be avoided. Comp time certainly complicates that, would require more and more accurate record keeping. Policies would be important to have. Accuracy would be very important. The other thing that we want to be aware of is that some of us rely on what we call the de minimis rule to exclude small amounts of work time. The courts have been reluctant, I think increasingly reluctant, to exclude large amounts of work time. You still find some court decisions that will exclude maybe up to 10 minutes a day, but the courts are more and more focused on, is it administratively difficult really to record that time? Some courts ask that if it's, small issue like starting up your computer, should you do that? Should you just add those 2 or 3 minutes to someone's time card every day rather than omit it and, over time create a large potential liability for yourself? So I think we have to think hard about the need for very accurate record keeping. The more accurate, the better. Paying employees to the minute, I would say, is your best practice. It's not the only practice, but it's a good thing to do. And with that, I think we might go to the question and answer series. Vivek, do we have some questions?
Their workforce. Our unique differentiators compared to other vendors are our true SaaS-based delivery model and our world-class mobile apps that enable anytime, anywhere access for your workforce. Our intuitive interface that drives rapid adoption. Our truly flexible platform that helps you model your business processes without the need for custom programming, and a global compliance library that enables real-time compliance for your business. Thank you to all the attendees for their time. We will follow up with you, and you'll receive the webinar slides and the recording. In the meanwhile, if you have any questions, feel free to reach out to Brian or myself. You have the email IDs there. Have a nice rest of the day. Once the session is over, you'll have a quick survey. We are trying to gather feedback and we are trying to understand what kind of content we should be producing going forward. So your response is highly appreciated. Have a nice day.